This is Syndication Attorney Field Notes. I'm Tilden Moschetti, and I'm a syndication attorney. Today's field note is about the Form D deadline in a Regulation D private placement and how it runs 15 calendar days after the first sale. Here's the scene I keep seeing. A sponsor tells me the raise is going well. First investor is committed, and then I ask when they plan to file Form D. And they say, once the wire clears, that's the moment I stop them. Because in many deals, the clock has already started. So let me give you the direct answer first. Form D is generally due 15 calendar days after the first sale in your Regulation D offering, not 15 business days, 15 calendar days. Weekends count, holidays count. And Form D is a notice filing. You're not asking the SEC for permission to raise money. You're telling them a private placement is underway. That's it. Now, the trap is buried in two words: first sale. Most sponsors assume the first sale is the day the money lands in the account. Usually it isn't. The first sale is generally the moment an investor becomes legally, irrevocably committed to buy. And in a typical private placement, that commitment forms when you accept the subscription agreement. Often that's when you countersign it. Let me tell you why sponsors get this wrong so often. They treat securities filings like post-close cleanup. The mindset is we'll deal with the paperwork after the raise fills up and the property closes. But Form D readiness is not a post-close cleanup task. Your first investor commitment starts the clock. If you wait until the fund is fully subscribed, and that can take months, you may have blown past the window on day one. And here's the other reason a lot of sponsors lean on filing software or a generic calendar reminder. That software does not read your PPM. It does not know how your subscription agreement defines acceptance. It can't tell you the legal moment your specific documents recognize a binding sale. So the reminder feels safe, but it's pointed at the wrong date. So let's get the distinction crystal clear. The trigger is the binding commitment, not the cleared wire. Let me walk a simple timeline. Say an investor signs the subscription agreement on Friday. On Monday, you countersign and accept it. Then the wire clears on Thursday. In the typical acceptance structure, your Form D clock starts on Monday. That's the binding commitment. The Thursday wire is just evidence that the money moved. It's usually not the legal moment that starts your count. Think about an overseas investor whose wire takes 10 days to clear. If you wait for the funds before you start counting, you may have quietly burned 10 of your 15 days without realizing the clock was even running. Now, one honest caveat. The exact trigger depends on your documents. Your subscription agreement has language about how and when a subscription is accepted. That acceptance language is what defines your first sale. So don't grab a definition off the internet and assume it overrides what your counsel actually drafted. Look at your own documents and make sure your intake process matches them. Let me hit a few things not to assume because I don't want you to overcorrect. First, in a rolling raise, don't wait for the final close. Say you're raising $10 million and it takes 6 months to fill. Your Form D isn't due 6 months from now. It's due 15 calendar days after your first committed investor, even if that first check was only $50,000. The final close does not move the federal deadline. Second, you don't file a new federal Form D for every investor. That first filing opens the offering federally up to the amount you disclose. Later investors in the same offering don't each trigger a new federal filing. Third, the states run on their own clocks. State blue sky notice filings are generally triggered as investors from new states come into the deal. Your first Texas investor can trigger a Texas filing. Your first Ohio investor can trigger an Ohio filing. So the SEC gets one initial filing, but the states need ongoing attention throughout the raise. And fourth, on late filing. A single late Form D does not automatically void your Rule 506 exemption. So if you file on day 20 instead of day 15, that's not the end of your offering. But where it actually bites is at the state level. Some states charge late fees on delayed blue sky filings. Ohio is a well-known example. And those late fees are dead money. They don't improve the asset. They don't protect investors. They just drain the offering. So here's the field note. Treat Form D readiness as part of accepting your first subscription, not as something you handle after the deal closes. The moment you countersign that first subscription agreement, the clock is likely running. Calendar the 15 calendar days right then and aim to file by day 12 or 13, not day 15. Give yourself a buffer because Edgar has limited hours and problems always show up at the worst time. And tie your investor relations process to your counsel. When a subscription gets countersigned, somebody needs to tell the person who files. Don't let legal find out about your first committed investor 3 weeks later. The rule itself is short. The discipline is knowing what first sale means for your deal. The longer written version is in the show notes. I'm Tilden Moschetti, and that's today's Field Note.